Hello. Today we're going to talk about a very important topic such as a contract. Many people who contact the Bureau face a significant problem when they simply cannot identify or interpret the agreement they've reached. Quite often in a court of law, they find that they cannot clearly justify what they actually meant. If you really want to steer clear of these kinds of legal issues and want to be able to successfully negotiate and conclude proper contracts, I highly recommend listening to today's dialogue with Marina Smirnova. She is a senior specialist at our bureau who will try to explain the main points regarding the conclusion of a contract. Hello, Marina. Welcome to the show.
Hello, Vladimir.
I have a question for you regarding the contract. This is a very serious question, a very relevant topic. Could you tell us in a few words what it actually is? When can one understand that the contract is concluded, or is it just some agreement that is not a contract? How can a person tell if they have reached some kind of contract or not?
The law states that a contract is a deal between two or more people. According to the interpretation of the law, a contract is, in simple terms, an exchange of people's wishes in order to succeed in achieving a mutually beneficial common goal.
Generally, how do we know if the parties have reached a contract? For example, let's say I promise to buy your watch for 100 euros. Is this a contract or not?
It will be considered a contract if, yes, I give you my consent to sell this watch.
Right.
That is, to reach a formal agreement, people must come to some common denominator.
And what if we didn't agree on the price, for instance?
Then there is no contract because the price is one of the most important terms of the contract.
And what if we agreed that I would buy your watch if you sell me your car for 200 euros?
Well, in that case, we're talking about a contract with a condition precedent or the occurrence of any condition whatsoever.
Well, in other words, how can we understand if they've reached a contract? Did I understand correctly that they reached a compromise on all the main essential aspects of this particular contract?
Yes, exactly. But that's the problem because people can't always determine post factum specifically what they were agreeing on. Sometimes it happens, and in our life it often happens when people think they've reached an agreement on some things, and then it turns out that everyone understood it in their own way. And this is where disputes arise that are worth resolving.
Well, let's say, sorry for interrupting you. Let's go back to this very simple contract. I'm buying a watch from you, but I'm not saying which one. And we have an agreement. I'm looking at your watch. Let's say the cost of this watch is, relatively speaking, 400 euros. And I say, I'll buy this watch from you for 200 euros, but I don't say this specific watch. And you understand some other watch that is somewhere nearby. That is, I don't specify the subject.
This is also a problem because just like the price, the specific subject of the contract is one of the fundamental defining factors for understanding whether a contract is legally concluded or not. It is for this very reason that I always suggest signing a written agreement, no matter how important or significant the subject of this contract is, what the price is, and so on. This is because quite often people just do not reach an agreement and then they have to deal with the consequences that follow.
Right? And if we're talking about a written contract, does it have to be notarized, or is a simple written form sufficient?
This is regulated by law because there are certain deals for which a written form is mandatory. For example, real estate transaction. Without a written form, such a transaction would be considered null and void. Consequently, no contract ever existed and none exists now. But to ensure that our normal everyday business doesn't come to a standstill or get bogged down just because there's no written form, the law doesn't prohibit making agreements, including verbal ones. But one must take a reasonable approach here. If the subject of the contract is more complex, if it's, say, a long-term agreement, right, that's signed and will remain in effect over a certain period of time, then there's a clear recommendation to agree and record the main points of the contract on paper.
Suppose two parties reached an agreement and signed a contract on paper. They put everything they wanted in there. And then when it came time to perform, each of these parties interprets one provision or another of this contract differently. What is the court supposed to do in a situation like that when people interpret the same thing in different ways?
That's a complex and interesting question because contract interpretation is one of the most complex and interesting things there can possibly be. First, you have to determine whether you really did misunderstand the subject of the contract, because spelling out every single aspect down to the smallest detail is just not reasonable. But if you really do happen to find yourself in a situation where you have entirely conflicting and divergent understandings of what you mutually agreed upon with your partner, then the court will step in to interpret the contract from the objective perspective of an independent third party. In other words, how an ordinary, average, normal person without any specialized knowledge would understand it.
And what if this contract, for example, was signed as part of a specific professional activity or business practice? What happens then? A judge might not have the business experience necessary to interpret such a contract.
A highly qualified expert is brought in, or someone who has specialized knowledge in that specific field. They provide clarification and thoroughly explain how it should be understood.
We'll say if we take a field like construction, or if we take the field of supply chains, for instance, and a question arises regarding the cyclical nature of the work or the quality of the work performed, and the parties didn't specify the quality of performance or a certain sequence of stages for the work in the contract. And because of that, questions arise about certification, and questions arise about payments and the handover, commissioning the facility, and so on. What does a judge do in cases like that?
There's another option here besides an expert. This is a reference to the standard practice that is applied in this field. For example, if it's construction, it's a very complex process, and it's clear that you can't foresee every detail there either. But you can look at how things are typically done in everyday practice
Well, let's say,
when solving it.
yes, well, let's say if the parties agreed, if they managed to reach a compromise and reach an understanding regarding a certain clause of this contract, but the judge, for some reason, decided that their agreement is invalid, void, and it shouldn't be that way. It shouldn't be. What happens in that case?
Could you explain your question?
Well, for example, suppose they decided that they drew up a written contract that has, say, 15 clauses, and one of those clauses is illegal or unenforceable from the standpoint of current legislation or some international acts. What would the judge do then?
Well, in this case, that clause is simply considered null and void. And if this contract is enforceable without that clause, then the contract remains in full force and effect in all other respects.
And if this leads to the entire document, the whole contract, being void, what happens then?
Then that contract will be rendered completely null and void.
If the contract is invalid, then accordingly the transaction doesn't take place. And then the question of damages really does arise. The question arises
Yes.
about the return of everything that was received or unjust enrichment and so on. Absolutely. And what else can be noted in the context of a contract? What other aspects are important?
Well, consequences are one of the things worth thinking through when entering into a contract. It is also important to decide on the jurisdiction and applicable law, because in this modern globalized era, many deals are made that go far beyond national boundaries, that is, companies registered in other jurisdictions. Accordingly, in our work, we more and more often encounter the application of European law, but sometimes the law of third countries can also apply. It's a complex topic. It's regulated by laws, conventions, and so on. And one must think through such consequences here.
It's very good that you touched on this topic. So let's say there's a contract. Well, I really hope that all the viewers and listeners clearly understood exactly what that concept is. It's a bilateral deal where the parties have reached a compromise, the parties have reached a common understanding that is valid and legal. For the sake of argument, let us suppose the parties agreed that Spanish law applies and the legal proceedings are in Africa. What specific steps should be taken to address this particular situation then?
That's complicated. One must find out why it was done that way, what the connection is, and why, if they approach the contract thoughtfully, then such a choice of jurisdiction and applicable law must be dictated by something. So you have to understand and figure out why it's like that.
So, what do you recommend for choosing a jurisdiction and the governing law for the contract?
The parties must understand where they can realistically conduct legal proceedings, which law they understand, and where they can afford it financially, because litigation is a rather expensive procedure.
Often,
and to avoid those risks.
yes, global corporations often dictate their jurisdiction. To be precise, it mostly concerns Anglo-Saxon common law and various international arbitration venues or courts that fall outside the jurisdiction of the European Union. What should one do in such a case?
There is another option. You can agree on arbitration proceedings. That is, the parties choose arbitration. This can include international arbitration as well. Arbitration proceedings are typically much shorter in duration, highly streamlined and efficient, and they are just as legally enforceable as a regular court decision.
If I understand correctly, the contract should include a clause referring to a specific arbitration. And regarding the choice of substantive law that will govern this contract, what do you recommend using?
Yes, of course. It is a clause. For instance, a good example. In Estonia, the Chamber of Commerce website provides specific templates for how to include this in a contract. And it immediately draws the parties' attention to the fact that you must choose the number of arbitrators to handle your dispute right away. You can calculate the cost of the arbitration proceedings, the approximate time frame, and understand what it might entail. You choose the jurisdiction, international commercial arbitration, or, for example, the arbitration of the Estonian Chamber of Commerce. That is also an option.
That is for forum shopping. That is where the dispute arising from the application of this contract will be heard. And what about the choice of law?
It is advisable to select the applicable law at the contract signing stage and have both parties reach a mutual agreement regarding it so that it is acceptable to everyone.
So both parties choose, so to speak, voloõiguseadus, that is the Estonian Law of Obligations Act, because the dominant company is located in Estonia, the leading company, a large company that signed a contract with, say, a company in Greece, let's say a small office there, and Estonia dictates its terms. Estonia chooses the Chamber of Commerce arbitration and the application of voloõiguseadus, the Law of Obligations Act. The Greeks do not agree. They say, no, we do not want to sign this contract. Then what happens in that case?
Well, in that case, the parties will not reach an agreement on one of the very important matters, right? I would recommend in such a case, if it is an international contract with different jurisdictions, to choose truly international arbitrations. All the rules are there. You can review them. So before signing the contract, you can already have a rough idea of what it will look like, what it will cost, and how it will proceed.
And what if the parties did not agree and completely failed to mention the applicable law? Suppose they chose a venue for litigation but remained completely silent regarding the law that will apply to that specific contract. What is the law? The law, as I understand it, is what the judge will apply in the event of a dispute over a specific contract. Am I correct?
Yes, you mean the application of international conventions?
I think there will be no other choice but to apply some conventions. If, say, two European companies have an agreement, say an Estonian company and a Greek company, and performance takes place on Estonian territory, how will this be how will this contract be understood at all?
Then the established legal norms and regulations that govern such situations will automatically come into force. That is, there is a fairly large legislative base, and the analysis of such cases is a very interesting and labor-intensive process. This is because you need to analyze a large volume of documents and thoroughly determine the exact geographic location where the transaction took place. If we are discussing potential damage or harm that will inevitably result in significant financial losses, then we can proceed based on the general principle of the place of damage and so forth. So it is quite difficult to provide an answer to this complex question in a simple manner.
So it is necessary to refer to some specific directive or regulation.
And not just one, more than one, yes. Analyze the situation, what exactly happened, what each party did, how they fulfilled their obligations. That is, a lot depends on the specific factual circumstances of the case.
Good. And if we change the subject and say, don't talk about commercial enterprises, but talk about individuals in the context of a contract, well, say a person wants to buy an apartment, or a person wants to buy a house, or a person wants to order a service, and for this he needs to conclude a contract. And here he encounters such a phenomenon when he arrives, and there is no contract at all. What in that case? Will the contract be considered concluded at least in oral form? How will it be regulated at all?
If we are talking about real estate, then no. Keep in mind that in Estonia, all real estate transactions are required to be in writing.
That's clear. And what if he wants to borrow money? Suppose he says, I want to borrow some money from you. And the other one says, okay, I agree. Here's the money. Let's agree that I give you 10,000 euros at 10% interest per annum. So was a contract concluded between them or not?
Yes, it was. But the question will be the burden of proof. Because if in the end one party does not fulfill its obligation and the other party to the contract has claims or damages, then the burden of proof will lie on that party. And proving what you agreed on orally is considerably more difficult than if it were formally documented in a written format on paper.
But the burden of proof. Explain to us what the burden of proof is.
The burden of proof is the legal obligation of a party to present and substantiate with circumstances, credible evidence, and witness testimony that will establish the factual basis of a claim.
In other words, to prove your statement.
Exactly.
As an example, if I were to lend $10,000 at 10% per annum, what specific circumstances should I prove?
Exactly the ones you listed.
That is, that I lent the money and that we agreed on 10%.
Yep.
And if that party says, yes, you lent me money, but we didn't agree on any interest, what happens then?
A matter of proof. And again, if the parties are unable to prove their positions in any way, then the law will be applied. And the law says that in the event, as you said, one individual lent another individual money, then the law provides for a standard rate of interest, which can be applied and which can be legally demanded.
So the first thing I have to prove is the fact that I transferred this money. Say there's no receipt, there's nothing, there's no contract. I just handed over the money and from hand to hand. So I have to prove the fact that I transferred it. And say, what if this fact is proven, say, by a bank transfer, and the other side claims, well, I returned it. Who has to prove that he returned it or didn't return it? Do I have to prove that he didn't return it to me, or does he have to prove that he returned it?
Each party always proves its own assertions.
Mm-hmm.
So if the opposing party claims that it was a repayment and not a receipt, then the legal burden of proof rests entirely upon her shoulders. She must provide sufficient evidence to support that claim. It must be proven if it was a repayment how this money was received.
Mm-hmm. So the performance of the contract that took place between us is as follows. We agreed that I lend him a certain amount of money and he returns it to me with interest. And he must prove, say, either performance or excusability of non-performance, as I understand it.
Yes, exactly. But as for monetary obligations, usually based on the law, it is considered that monetary obligations are not excusable.
So if, say, he were to present a version of events where he did not return the money to me because I deliberately turned my back on him, walked away, or otherwise did not accept the money from him, would this be considered a legally excusable set of circumstances?
If the specific individual who is supposed to receive the money categorically refuses to accept it, this situation could potentially be considered a violation in turn on his own part.
So if I don't accept it, then it's already like my violation, it turns out.
You must explain why you aren't acting.
Mm-hmm. Well, I was very offended by him. He's not returning the money to me on time.
Offense isn't considered.
I'm offended by him and I don't want any more money from him. And that's it. So each party must prove the assertions on which it builds its position.
Yes, its claim, yes.
Good. Marina, what else could you emphasize as important in the context of a contract? Concluding a contract, the correctness of a contract, the completeness of a contract, the clarity of a contract, for those who are watching our program.
I would say that one shouldn't be afraid of contracts. That is, it's better to agree in writing, especially if it's a more or less significant subject, expensive if the consequences will matter to you, and you want to avoid any negative consequences for yourself. As for the contract, in principle, it can be concluded in a very straightforward and basic format. You don't necessarily need to have any specialized legal expertise or technical knowledge, but it still makes a lot of sense to consult with a lawyer and get their expert opinion and assessment. Because in the future, this can save you from very big problems and costly and time-consuming legal proceedings.
Thank you very much, Marina. We'll end on that. I hope that our conversation was to some extent interesting for our viewers. Thank you very much.
Thank you.